I was driving back from my lawyer's office on a Tuesday afternoon in late October, and I remember thinking the sky over Hamilton looked almost too blue for that time of year. The call had come that morning while I was having my second coffee. My brother's a state lawyer. A woman named Karen Price spoke in that careful, measured way lawyers use when they're about to change your life. She told me my brother had passed 3 weeks earlier. Cardiac arrest, alone in his apartment in Edmonton. She said he'd left everything to me. Everything turned out to be his house in Burlington. A detached two-story on a quiet street backing onto the escarpment, paid off, assessed at just over $800,000, and his investment accounts. Roughly $420,000 split between a TFSA and a non-registered portfolio. Karen had already filed the paperwork. Probate would clear within the month. She just needed my signature. My brother and I hadn't spoken in 2 years. Not since a disagreement at Christmas that I'd told myself wasn't serious enough to bother fixing. I was wrong about that. The guilt sat in my chest the whole drive up the QEW, thick and immovable. He had left me everything, and I hadn't even known he was sick. By the time I turned onto my street in Ancaster, I'd decided what I was going to do. My son and his girlfriend had been living with me since the spring. 7 months of watching my grocery bill double, and my savings account thin out, listening to reasons why the job market was impossible and the timing was never right. I'd been patient. Patient in the way fathers are when they still believe things will turn around. But now, I had options. I could help them properly. Maybe set them up with enough for a down payment and finally get some space back. I was 64 years old. I had maybe 20 good years left, and I didn't want to spend them being a soft place for 2 adults to land indefinitely. I parked in the driveway and sat in the car for a minute, just breathing. The living room curtains were open. I could see the television was on. My son's truck was in front of the house, which meant they were both home. I got out, and that's when I heard them. The kitchen window on the side of the house was cracked open a few inches, the way my son always left it when he was cooking. Voices drifted out, sharp and close. I wasn't trying to listen. I'd taken maybe 4 steps toward the front door when his words stopped me cold. Id summer they might. The Atelmuns, though. That's the thing. If he adds us to the will before we move, we lose control of the timing. I stood on the concrete path between the driveway and the front steps. My hand was still holding my car keys. My girlfriend's voice came back, lower but still clear. So we don't wait for the will. We go the other route. Get him assessed. If he can't manage his own finances, he's 64. He goes to the gym. He's not incompetent. He doesn't have to be incompetent. He has to look it. There are clinics. I looked into it. You fill out a form saying you're concerned about a parent's capacity to make financial decisions, and they schedule an assessment. If the assessor is the right person, what does that mean? The right person? A pause. I heard the refrigerator open and close. It means some of them are more flexible than others. Bryce found one in Oakville. Used him for his uncle last year. Cost him about $2,000, but the paperwork went through in 6 weeks. Once there's a finding of diminished capacity, you apply for power of attorney. Emergency basis. Dad wouldn't even have to contest it publicly. By then he's legally not in a position to. I stopped breathing. And the house? My son's voice had gone quieter, more careful. Goes into the estate, which we control under the POA. The Burlington property too once probate clears. Bryce says the whole thing is worth over $1 million too if you include the portfolio. He'd fight it. With what? His word? If the documentation says he's not capable of managing his affairs, his word doesn't count for much in front of a family court judge. A beat. Look, he's gonna give it away eventually anyway. To charity. To whoever. You said yourself he's been talking about setting up some kind of fund in your uncle's name. That's your inheritance. We're just getting ahead of it. Your inheritance. We're just getting ahead of it. Your inheritance. I turned around and walked back to my car. I didn't trust my legs to carry me through that front door, without my face giving everything away. I sat behind the wheel for a long time. My hands were shaking, and I made myself flatten them on my thighs and wait until they stopped. I've spent 31 years as a family court mediator. I've sat across from people in the worst moments of their lives, custody disputes, financial abuse, elderly parents brought in by their children under conditions that made me sick to think about. I knew exactly what they were describing. I'd seen the paperwork. I'd watched it happen to other people's fathers. Now they were planning it for mine. I started the car and left. I drove north without any real destination and ended up parked outside a Tim Hortons on the edge of Dundas, watching people come and go through the glass door. An older couple shared a table near the window, coffee cups between them, not saying much, just being in the same place. I thought about my brother dying alone in Edmonton and decided I wasn't going to let grief make me soft right now. Grief could wait. What I needed was to think clearly. 31 years in family court gives you a particular way of looking at situations like this. You stop seeing the emotional content first and start seeing the structure. Who has what? Who needs what? What can be proven and what only sounds plausible? What did I have? An overheard conversation. No recording, no witness. My word against two people who would say I'd misunderstood, that they were talking about something else, that I was, and here was the irony, confused. What did they have? Time and proximity. They were living in my house. They had access to my mail, my documents, my routines. If they were serious about this, they'd already started building the case. Small observations, noted dates, maybe even talking to my doctor's office under the guise of family concern. I needed to move faster than them, and I needed to be invisible while I did it. The first call I made was to Sheila Barton. We'd worked parallel for years. She was a family law solicitor in Burlington who specialized in elder financial abuse. I'd referred clients to her more times than I could count. She picked up on the second ring and I told her I needed to see her today if at all possible. Today, as in this afternoon, she said. Today, as in the next 2 hours. A pause. Come at 4. I'll move something. I sat in her office with the winter light going flat outside her window and told her everything. She listened the way good lawyers do, without reacting, just letting it settle. When I finished, she set down her pen. First thing, she said, do not go home and confront them. That closes your options. I know. Second thing, they mentioned a specific name. Bryce, and a clinic in Oakville. That's what she said. I'll make some calls tonight. That's a small enough world that I might be able to find out who they're talking about without tipping anyone off. She folded her hands on the desk. You need recordings. Ontario is one-party consent. Any conversation you're physically part of, you can record. But conversations you're not present for require their knowledge or a court order, and we're not at the court order stage. I understand. Can you get access to their phones or documents? No, and I wouldn't want to. I want whatever we build to hold up. She nodded slowly. Then here's what we do. You go home tonight. You act normal. Tomorrow, you call your brother's estate lawyer, and you instruct her to add a notation to the file. Not a change to the will yet, just a notation of your intentions and a request that any third-party inquiries about the estate be flagged to you immediately. Clinics, lawyers, anyone asking about the probate status. They'd have to identify themselves to do that. Exactly. If your son or his girlfriend starts making inquiries, we'll know. She reached for a notepad. I'm also going to prepare an enduring power of attorney document, naming me as your financial representative in the event of incapacity. Ironically, it's the best protection you can get right now. If they try to apply for emergency guardianship, the court will see you already have a designated attorney of record, and the application becomes much harder to fast-track. I hadn't thought of that. 31 years in family court, and I hadn't thought of the most obvious defensive move. That's what shock does. One more thing, Sheila said. I need you to start keeping a contemporaneous log. Time and date every interaction with your son and his girlfriend that feels off. Every question they ask about your finances, your estate, your health. Write it down within an hour of it happening. Date and time details your own state at the time. If this goes to a hearing, that log becomes your credibility. I drove home through the dark and let myself in through the garage. They were in the living room. My son looked up from his phone. Hey, we wondered where you got to. Ran some errands, had a coffee with an old colleague. I set my jacket over the chair. Karen Price called this morning. About your uncle's estate. My son sat up straighter. Oh yeah? He left me the Burlington property and his investment accounts. I kept my voice easy, flat. Going through probate right now. Should clear in a few weeks. His girlfriend had come in from the hallway. Her expression did something quick and small. Not quite surprise, more like confirmation. Wow. That's a lot to take in. It is, I said. Listen, I'm going to make some soup. You two want some? Sure, yeah. My son stood up. Need any help? I've got it. I sit at the stove and let them ask their careful questions. How much was the property worth? Was I going to sell or keep it? Had I thought about what I was going to do with the money? I answered vaguely, warmly, like a man who is still processing unexpected good news. I watched my son's girlfriend take out her phone and angle the screen away from me while she typed something. I noted the time on the microwave clock. That was the beginning. Over the next 10 days, I did what Sheila had outlined and a few things she hadn't suggested, but that my years in court told me mattered. I had a casual conversation with my family doctor and mentioned just in passing over a routine visit I'd already had scheduled, that I was going through a significant inheritance process and feeling a bit overwhelmed. She noted it in my file the way doctors do. I was seen by a professional, in good health, managing a stressful life event normally. That note would matter later. I also started recording, not secretly planted devices, nothing theatrical. Just my phone, sitting face down on the kitchen table, running a voice memo app during dinner conversations. Any conversation I was part of. Legal under Ontario law. Admissible in court. Invisible to anyone who wasn't looking for it. On the 4th day, my son asked me if I'd ever thought about simplifying my affairs. His phrasing was careful, almost rehearsed. What do you mean by simplifying? I asked. Like you're managing the Hamilton house, and now there's going to be the Burlington property. That's a lot to keep track of. Some people in your position set up a family trust, hand over the management to someone they trust. I said. I'll have to look into that. He mentioned it again 2 days later, from a slightly different angle. Had I met with a financial planner yet? Did I know what the tax implications were on the investment accounts? He offered, with a casualness that didn't quite land, to help me find someone. On the 7th day, his girlfriend mentioned that she'd been reading about cognitive health and aging. Apparently, some people in their early 60s showed early signs of things they'd never recognized themselves. Had I thought about doing a baseline cognitive assessment? Just to have the data, she said. Then, if anything ever came up, you'd already have a comparison point. That's thoughtful, I said, and I sat on my hands and didn't say anything else. That night I sent the recordings to Sheila, and she forwarded the relevant clips to a contact at the Ontario Provincial Police Elder Abuse Unit. The contact, a detective named Sandra Kwok, who had worked this kind of case before, called me the following morning. The conversation you overheard is your core evidence, she said, but it's not admissible as a standalone. What we need is them completing an act. Paying for a fraudulent assessment, filing a false capacity document, or attempting to. She paused. The name, Bryce. Do you know a last name? No. That's okay. Your lawyer's working on the Oakville connection. Once we identify the assessor they're planning to use, we can confirm whether that person has prior complaints or is currently under review. That changes the severity of the charges significantly. I asked what the charges would look like. At minimum, conspiracy to commit fraud under the criminal code. Potentially elder financial abuse under provincial law, though that's a more recent framework and still being tested. The POA scheme, if they filed it with false documentation, would be fraud on the court. That's serious. She said it calmly, the way people in her line of work learn to say things like that. My son. Fraud on the court. I went for a walk after I hung up. It was early November, cold enough that the leaves had come down off the maple out front and were sitting in a wet pile by the curb. I walked the neighborhood for 40 minutes and let myself feel it, the loss of it, the specific grief of learning that the person you raised has been sitting across the dinner table from you calculating your value as an obstacle. It wasn't anger exactly. It was more like watching the floor drop out of something you thought was solid. Then I came back and made dinner and sat at the table and talked about nothing much. And when my son's girlfriend mentioned that she'd heard Burlington property values were still holding, I said, yeah, I should probably get a current appraisal. And she said, definitely, with a little too much energy, and I let it go. Sheila called that evening. She'd found the clinic, a man operating in Oakville under a private practice banner, no hospital affiliation, who'd had 2 prior complaints filed with the College of Physicians and Surgeons in the last 4 years, both related to capacity assessments that had been subsequently overturned. He hadn't lost his license, but he was on notice. Detective Kwok already knew his name. They haven't booked an appointment yet as far as we know, Sheila said. But your son made an inquiry call to the clinic 3 days ago. We have that from the clinic's intake records, which Kwok obtained through a production order. 3 days ago, while I was making soup, while I was sitting across from him at the dinner table. What's the plan? I asked. We let them book it. We need them to show up and hand over money for a fraudulent document. At that point, it becomes a completed act of fraud, rather than a conspiracy. The difference in how a Crown prosecutor can proceed is significant. I'd be going with them. Yes, we need you present both to confirm the scenario and to protect you. Detective Kwok will have plainclothes officers in the area. The moment money changes hands, they move in. I sat with that for a moment. What do I do between now and then? You keep performing. You're the trusting, slightly overwhelmed father dealing with a significant inheritance. Warm, maybe a little vague about the details. You let them feel like they're ahead. The appointment happened 12 days later. My son came into the kitchen on a Saturday morning and said he'd set something up with a health clinic. Just a general wellness check, he said, given everything I was dealing with. He'd done some research, found a good place. He said it with the tone of someone doing me a favor. I said it sounded fine. I said he was thoughtful for doing that. We drove out to Oakville on a Wednesday, the 3 of us in my son's truck. I sat in the back. He and his girlfriend talked about traffic and a podcast they'd been listening to, and I watched the 403 pass by through the window and kept my breathing even. Detective Kwok had texted that morning, in position. You're good. The clinic was in a commercial strip, between an insurance broker and a nail salon. No hospital branding, a small sign on the door that said Integrated Health Assessment Services. Inside, a waiting room with 2 chairs and a fake plant, and a man in his 50s in a dress shirt who came out and introduced himself as the doctor. He spoke to me briefly, a few minutes of questions about my sleep, my memory, whether I ever felt confused or overwhelmed. I answered slowly, let some sentences trail off. Looked at my son once or twice for confirmation, the way a person would if they weren't quite sure. Then the doctor excused himself, spoke to my son and his girlfriend in a lowered voice near the front desk, and I watched from my chair as my son pulled an envelope from his jacket. The doctor reached for it. I don't know exactly what I expected to feel at that moment. Some kind of release, maybe. Instead, I felt very still. The door opened, and Detective Kwok came in first, badge out, and behind her 2 plainclothes officers who'd been in the parking lot. She identified herself and told everyone not to move. The doctor pulled his hand back. The envelope sat on the desk between them. My son turned and looked at me. I stood up from the waiting room chair. I wasn't playing the confused old man anymore. I just looked at him. Dad, what's happening? I heard you, I said. At the house. The kitchen window was open. The color left his face. I heard everything you planned, both of you. I kept my voice level. I'd spent too many years in a courtroom to let it waver now. I hoped I was wrong about what I heard. I spent 2 weeks hoping I'd misunderstood. I paused. I hadn't. His girlfriend said something about a misunderstanding, about not meaning it the way it sounded. Kwok's officers moved between us, and I stopped listening. I gave my statement at a detachment in Oakville that afternoon. 3 hours. A stenographer, Sheila, sitting beside me. When we finished, it was nearly dark, and I was tired in a way that had nothing to do with sleep. Sheila walked me to my car in the parking lot. Interim protective order will be granted tonight, she said. They can't contact you, can't enter the Hamilton property, can't make any inquiries about the Burlington estate. The accounts are frozen pending investigation. She looked at me carefully. You should call someone tonight. Don't be alone. I called my neighbor, Carolyn, who'd lived 2 doors down for 15 years, and who had the particular quality of good friends, which is that she didn't say much when she arrived, just put the kettle on and sat at my kitchen table and let me talk when I was ready. I talked for a long time. About my son. About who he'd been when he was 12 years old and stubborn in ways that made me proud even when they made me exhausted. About how I'd driven to his hockey games on February mornings when the temperature was -20 and thought that this, showing up in the cold for someone you love, was the whole project of being a father. About whether I'd missed something, failed to see something forming in him that I should have seen. Carolyn let me work through it and didn't offer conclusions. The arraignment was 6 weeks later. My son and his girlfriend faced charges of conspiracy to commit fraud and counseling an offense. The doctor lost his license the same week, a decision from the college that came faster than I expected, apparently because Kwok's investigation had turned up 2 additional cases he hadn't previously disclosed. His patients were notified. Some of them had cases that would be reopened. I sat in the court building for the arraignment and watched my son stand before a judge and listen to his lawyer enter a not guilty plea. He looked smaller than I expected. He didn't look at me. I moved into the Burlington house in January once probate had cleared and the legal protections were in place. It's quieter than the Hamilton house. The backyard faces a small woodlot, bare now, but the property management company told me it fills in by June. I've been told the neighborhood has a good walking path along the escarpment that I haven't found yet. I think about my brother more than I expected to. His note to me, the one Karen Price read aloud in her office. Brief, handwritten, folded inside the will. He'd written that he'd always meant to say a few things and ran out of time, the way people do. He said that of the 2 of us, I was always the one who did things right even when it cost me something. I don't know if that's true. I know what it cost me this time. The trial date is set for the fall. Sheila says the Crown is confident. I don't let myself think about the sentencing. I focus on the woodlot in the backyard, on learning the neighborhood, on getting through this winter and whatever comes after it. Some mornings I make coffee and stand at the kitchen window and feel the specific weight of being 64 years old and more alone than I planned. It's not drama. It's just the thing that's true. But the window is mine. The house is mine. And no one is planning anything in the room next door. That's what I have. For now, it's enough.